else you want to talk about?
Yes, that was just as to point one. Second, prior bad acts. As to the witness, Mr. Glass, any prior arrest that did not result in any convictions. In addition to, counsel brought up a alleged shooting incident that was denied by the witness, and there was also allegations of him being, just generally involved in bad acts. So we moved to exclude any of those. He does have 2 prior felony convictions, so those would be what counsel's testimony should be limited to. And finally, the drug use, which I cited to Edwards versus State, which is 548 Southern 2nd, 656, Florida Supreme Court, 1989, regarding when counsel can inquire from a witness whether or not he's utilized drugs. The witnesses admitted and did admit in deposition that he did smoke weed on the date of incident. But however, counsel did inquire as to his general drug use, and so the state would seek to exclude any general drug use that's not related to either the date of the incident or, according to Edwards versus State, any other testimony that would affect his ability to recall events. And those are the state's 3 motion elements.
Well, it's 1 motion eliminated, but 3 paragraphs.
Yes, 3 paragraphs, yes.
Thank you. Defense Mr.
Good morning, Your Honor.
Good morning.
As to, I'm trying to recall, as to the issue of drug use, I'm not thinking that it's our intention to date his drug use back to birth. However, we know that one of the lasting and long-term effects of chronic marijuana usage is affects one's memory. So the fact that I think when he was asked, do you smoke marijuana, his answer was yes, and how often, the answer was whenever I can. I'm not sure that we should be limited to the day in question, because the impact of such chronic use, whenever he can get his hands on it, impacts his ability to recall matters. With respect to his prior bad acts, there are 2 felonies which are clearly are impeachment. And beyond that, however, he was charged. This is a witness who made himself deliberately unavailable to the parties for years. He then gets charged in May of this year with a crime, and now and then watches the proceedings on television and has suddenly made himself available. That goes to bias his intent.
I don't think the state was suggesting that you couldn't ask questions about whatever current charge he has. Are you suggesting that?
No, Judge, I didn't address that, because he can ask about the charges, about the maximum, minimum penalties, and I would agree that he could ask whether or not he's been incurred in favor in exchange for his testimony as it relates to that.
With regard to the current charges.
Correct.
And well, if the state's position is we can't impeach him with anything beyond the current charges and his felonies, we agree. I can't remember what the first point was.
So it was self-serving hearsay statements of your client.
First of all, it's not a statement. A statement are utterances. The question that was put to the witness was whether or not Mr. Demons ever admitted involvement in the activity. The answer is no. There was a time during which the witness indicates that he was inquiring of various people what may have happened. And him saying that Mr. Demons never admitted involvement in the offense is not him uttering a hearsay statement. It's him denying the existence of any statement, hearsay or otherwise. So I don't think there's a hearsay exclusion to the failure to admit involvement in an offense. So I don't think that that question ought to be precluded if, in fact, we decide to put it to the witness.
Thank you. Well, regarding the first issue about the witnesses' alleged testimony that the defendant, Mr. Demons, didn't admit to him that he was involved in it, that's not something the witness observed or anything. That's in essence an exculpatory statement. I agree with the state. You can't do that. I granted regarding the prior bad acts and impeachment, we're all on the same page. You can ask about whatever the pending charge is. You can talk about that in the prior 2 felonies. But as to other uncharged offenses that may have happened along the way, those are not. Can't inquire as to those. As far as the drug use, if he's using marijuana, cannabis at the time, that's all fair game. I don't see any issue with that. And if he uses it frequently, I don't see any issue with that either. I don't know that that's the type of. It may have been at one time the type of drug use that was concerned, but it stays in your system for a while, has effects on you. I think all that's fair game. I don't have any issue with it. And I understand Edwards talks about when you're under the influence of something, but if it's over a period of time, I've heard from various experts how long it stays in the system and how long it can do it. So it can be for a period of time.
Okay, and just to clarify, Your Honor's ruling, period of time meaning from the date of incident to current date, or even predating the date of incident?
Counsel, to me, it's fair game. They can go into it.
Okay, I just wanted to
I don't have
clarify.
any issue with it. All right.
And Judge, the defense did file a motion to exclude Trevion Glass from testifying at all. I don't know if they want to, or Your Honor wants to address it at this time.
We can address it at this time.
Sure, go ahead.
Did you have a chance to read my motion and the case law this morning?
I did.
All right.
Thank you.
So it's basic, as I stated in my motion. After 4 years, we're finally able to depose Mr. Trevion Glass. Interesting enough, as I set forth in my motion, and I attached the pages of his transcript, he states that it wasn't until he started watching YouTube, because this case was live streaming, and hearing his name repeated everywhere, that he decided to call up the prosecution. As I further stated in the deposition, specifically questions were asked about his independent recollection of this incident, and he clearly states, let me go to it, I wasn't aware who got into what seat that day, but from me watching what's going on, yeah, I know now, yeah. Mr. Howard then clarified that. Watching what's going on, do you mean the trial proceedings? He said, correct. Looking at this rule of sequestration, and we know it here as the rule dates back to biblical times. And going back into there, it's been well established that we need these protections of this rule of sequestration to prevent witnesses tailoring their testimony to match the testimony of the previous witnesses. And that's exactly what we have here. 2023, in the Bible they didn't have a TV live streaming into the courtroom. So most of our rules, when we were dealing with it, are saying, you cannot sit in this gallery and then come up on this stand and testify. But if he's sitting there watching from that TV, from the comfort of his home, there is no difference from him sitting here in this gallery and then getting up there and testifying. That is the crux of this rule, and that is exactly what it is meant to prevent. Sequestration of witnesses is one of the oldest and most time-honored rules in the court system. It's to ensure that we have effective truth-seeking. And we won't have effective truth-seeking if he's allowed to sit here, watch everybody testify, and get up there and then tailor his testimony to the last 3 weeks of evidence and other witnesses who have testified. I've provided the case law. I think the law is clear. reading into that case law, because this rule of sequestration, we do have a sister rule in the federal court system, 615. And they've actually gone on a little bit further with their cases to give us examples of out-of-courtroom communications that are not allowed. And they give us examples of witnesses sitting outside of the courtroom talking about what they testified with another witness who's going to testify. They talk about giving witnesses the transcripts of other witnesses and preventing them from testifying. In this case, again, he watched the entire trial. We don't even have to guess about this because he tells us in his own deposition that he's been watching this trial, that he's heard his name in this trial, and that's why he's decided after 4 years to come and testify. He must be excluded to guarantee my client a right to fair trial.
Thank you. What's this state?